The request made by the appellant was in terms turned down by the disciplinary authority. In considering the importance of access to documents in statements of witnesses to meet the charges in an effective manner, this court observed as follows. When a government servant is facing a disciplinary proceeding, he is entitled to be afforded a reasonable opportunity to meet the charges against him in an effective manner, and no one facing a departmental inquiry can effectively meet the charges unless the copies of the relevant statements and documents to be used against him are made available to him. In the absence of such copies, how can the concerned employee prepare his defense, cross-examine the witnesses, and point out the inconsistencies with a view to show that the allegations are incredible? It is difficult to comprehend why the disciplinary authority assumed an intransigent posture and refused to furnish the copies, notwithstanding the specific request made by the appellant in this behalf. Perhaps the disciplinary authority made it a prestige issue. If only the disciplinary authority had asked itself the question, what is the harm in making available the material? And weighed the pros and cons, the disciplinary authority could not reasonably have adopted such a rigid and adamant attitude. On the one hand, there was the risk of the time and effort invested in the departmental inquiry being wasted if the courts came to the conclusion that failure to supply these materials would be tantamount to denial of reasonable opportunity to the appellant to defend himself. On the other hand, by making available the copies of the documents and statements, the disciplinary authority was not running any risk. There was nothing confidential or privileged in it. On an examination of the facts, in that case, the submission on the behalf of the authority that no prejudice had been caused to the appellant was rejected, with the following observations. Be that as it may, even without going into minute details, it is evident that the appellant was entitled to have an access to the documents and statements. Throughout the course of the inquiry, he would have needed these documents and statements in order to cross-examine the 38 witnesses who were produced at the inquiry to establish the charges against him. So also, at the time of arguments, he would have needed the copies of the documents. So also, he would have needed the copies of the documents to enable him to effectively cross-examine the witnesses with reference to the contents of the documents. Full stop.